Hi, I'm CJ Holmes, independent real estate broker and founder of Homeowners for Justice. And today I want to take a few minutes to talk about what is currently available in the loan modification process. A lot of people, a lot of homeowners simply want to keep the house and they want a loan that they can afford. So what helps can I offer you today? And it's not just me, I'm just the voice explaining the things that I'm aware of that you might be able to use to help you keep your home. Before we proceed into some of the information in the website where I've linked all this stuff, I've got to tell you again, I'm not an attorney, I'm not a CPA, I'm not a loan modification or securitization auditor specialist. I don't do any of that stuff. I am a licensed real estate broker. I do transactions and try to help buyers and sellers do the best they can in the market when they buy or sell property. What you have to understand, please, is that we're just doing our very best to give you the most accurate information at this time, that this information can change and often does, that if you rely on this information, we can't be held liable for whatever results you might get or not get. The fact is that everyone right now facing foreclosure, trying to get a loan modification, are dealing with servicers that have been incented, they've been motivated to lie and cheat because they make so much more money by foreclosing. So even if you did everything right, that doesn't mean it's necessarily going to work for you, and I apologize for that. I really, really wish we could give you some guarantees, but we can't. I also want to point out that the content, both of this workshop and of my website that I'll be using, it's a library for your help and aid. This may change without notice. It often does. We get updated. Occasionally I do like a follow-up teach-in seminar workshop simply because there's more information or more effective ways to use this information. So with that said, what we want to talk about today is loan modifications. There's many government programs that they've tried, the federal government has tried. Most of them have been fairly dismal failures, and even these that are, quote, successful are just too little too late. And that's the discussion of another workshop, not today. I just want to briefly describe these three programs, which as of today, this is March 2013, still are in effect and do affect homeowners. HAMP is the largest one, the Home Affordable Modification Program, and it's specifically for modification of loans of owners that are in default. They've stopped making payments for whatever reason, either they lost income and couldn't afford the payments, or the servicer told them incorrectly that they had to be in default before they could get a loan modification. And this lie is propagated around the country. So, and we'll be talking more about that, just so that you're aware. HAFA, the Home Affordable Foreclosure Alternatives, this is basically cash for keys to owners in a short sale. And then HARP 2 is basically a refinance product for qualifying underwater Fannie and Freddie loans. So if your loan is owned by Fannie or Freddie, if you're still making your payments, if it's not too far underwater and it qualifies, and the lender that you've discussed this with doesn't have some other issues they cannot overcome, for example, private mortgage insurance or a second lender that refuses to resubordinate their loan. This is what has made this program fairly ineffective. So many problems. We're going to focus today on HAMP because I believe one of the reasons you may be watching this is either you are fearful of becoming underwater or stopping making your loan payments. You already have stopped making your payments. You don't know how to stop foreclosure. And maybe you've heard someone say, like me, that right now a loan modification is one of the best ways to postpone a foreclosure auction. As of January 1st, 2013, what we term SB 900 went into effect, that Senate Bill 900, and it changed various foreclosure laws. I'm going to review that briefly today. I have everything linked on the website. You can read it at your leisure and use that for your benefit. Nevertheless, it is one of the best ways to postpone a foreclosure auction. Before we start looking at the details, I really feel impelled to give everyone warnings. Upfront fees are scams. Please do not spend money up front. There's no need to. Your results with a loan modification are very well as good doing it yourself as it would be doing it with some free government help, much less having to pay someone over which you have no control, and you don't know if they're really going to work for you or not when you pay them an upfront fee. In California, anyone that's working in the state of California, it is illegal to charge an upfront fee. So please, if someone says, pay me to do this for you, just run away. Come to my website. Tell everybody to go to my website and do the effort for free. It's a little bit of work, absolutely, without a doubt. It'll take some effort. However, it will be well worth it. You'll be in control, and you'll discover things. Your ears are going to be tuned to things that are said and done far more than somebody else who doesn't really care that much about your personal situation. So free help is available. I'm going to show you exactly how to get that. Please understand that every trial modification program any servicer ever says to you, whereby you, the owner, would just send in some money to the servicer without signing anything or seeing anything in writing, that is simply a lie. They pocket those fees and they put them in what I've been told is an offshore slush account, and you're just out the money. Those payments are never applied to your loan, and they do not stop foreclosure. I'm going to tell you what to do. I'll tell you here, and then I'll show you in a minute how to fight back against this. Every time a servicer lies to you, you must file a complaint. And either, if it's a mega servicer, one of the 5 big banks, it would be to the OCC. If it's not a mega servicer, it's one of the other servicers now that the banks have sold most of that servicing off to wholly owned subsidiaries, it would be to the Consumer Financial Protection Bureau. And I have links to both of those on my website. Every time you talk to anyone about your loan, log it. Just have a spot. It doesn't have to be fancy. Just grab a piece of paper, write by hand who said what, who were these people, what was their employee ID. Write down who they are and what they said. Log everything that happens. And then definitely, I'm going to remind you again that yes, we're talking about loan modifications, but the whole point of today's discussion and expose on SB 900 is that right now, according to California law, every servicer that forecloses and the lender that gives them that right must have standing. I'm going to be using that word quite a bit, and basically standing means they have the authority. They have the proven authority. They have the documents that prove they have the authority to foreclose. And this is a powerful, powerful weapon that owners can now use, both for now to postpone auctions and to go after them for wrongful foreclosure. So, what we're going to talk about first, and then I'm going to show you the website where everything is linked, and I'm going to go through those links briefly so that you can understand what you're looking at. But the California Senate Bill 900, we call it the Loan Modification Law. You might heard it referred to as the Homeowner Bill of Rights. It basically does a bunch of things. The ones I'm focused on today, the ones that really count, single point of contact is in it, but the single point can be a whole team. So people are telling me they never get the same person. It's just a team. Who knows how many is on that team? The point is, that's not even as material as this. We're focusing on what's really material. It prevents dual tracking. And what that means is, once you are applying for a loan modification, you cannot be foreclosed. So this will postpone an auction. I have anecdotal evidence. I have contacts that work with me all the time. They're telling me the same thing, that they are being told by the servicer, as soon as I get your loan modification paperwork, I will postpone the auction. So if your OCC complaint doesn't postpone it, or even if it does, use that one. If your notary violation, notary complaint doesn't really work, keep using that one, try that one. Definitely use this one too. It can't hurt to have several irons in the fire and several strategies to keep your home. So it prevents dual tracking, and that's what dual tracking is. It means the servicer is going to talk to the owner about a loan modification, and while they're over here chatting with this hand, they're going to take the house in foreclosure. They can no longer do that. It is illegal. And if they do that, owners now have a right to sue for damages, and they can get attorney's fees and damages. It would be a material violation. Remember some of these words. Now, another thing that's really powerful about SB 900 is that if you're denied for a loan modification, most people are, and I'm going to discuss why that is, not legally, they're just denied. You can appeal that, and you can appeal that, and you can appeal that. Now, it also requires, you've already heard me say this once, it requires lenders standing, because the foreclosure documents must be accurate and complete and supported by competent and reliable evidence. That's standing. So now owners can use standing. And if they materially violate these rules, the lender, the servicer, and the foreclosure trustee can all be sued equally. And even if one of them is found at fault, they can all be held liable. So these are some very powerful changes now in the law. I really felt impelled to get out to you today. So at my website, when you go to hofj.org, here's the home page, and I want to bring out and point out a couple of the things I'm going to be talking about later today so that you'll know where I'm talking about them. Right here on the home page. Please don't think I make all this stuff up. I'm just the voice. I'm just sharing what I've heard and read and seen, and now I'm talking about. Right here on the home page, you'll see that William K. Black talks about 10,000 felonies a month. It's a short little video. I encourage you to watch it. Catherine Austin Fitts talks about fraud to the tune of trillions. I encourage you to read that article. The fact of the matter is, I've got the last year's Homeland Security report about money laundering linked, and now, of course, we just had last week another subcommittee on finance report come out about how JP Morgan Chase is a criminal enterprise. So I'm linking some of these key issues. You have to understand, the banks are not your friend. They are not telling you the truth, but we can fight back. So when you come to the homepage and you want to talk about loan modifications, this is what you do. Go to Foreclosure Defense and start at the Foreclosure Defense page. Here's where I've talked about the 11 considerations. I've already done a workshop on that with some warnings. Here's the OCC complaint, strategy number 1. Remember, I just told you, if any servicer ever lies to you, go right here. Now, that's for the mega servicers. Now, the mega servicers, they are the corporate shell game masters. They have created many other corporations, wholly owned subsidiaries. They play the shell game, and now they've sold the servicing and loan modification rights to some other wholly owned subsidiary that's offshore. Is not under the OCC, but they are under the Consumer Financial Protection Bureau. So if you have a complaint about a servicer, and you can look over here where it talks about, like, here's the mega banks. The 5 mega banks are the consent judgments. Anything under the OCC consent orders, those would be servicers. Aurora, Everbank, MetLife, some of these others, PNC. They may not be mega banks, but they are have a federal authority, and you can complain. And please do so. We need thousands of complaints to try to rein in these completely out of control banksters. That's number one. And I wanted to mention, as we get down to loan modifications, we're getting there, to always submit a qualified written request. I don't even care if you're not late on your payment. It cannot hurt for every person in this country to submit a qualified written request letter to their lender. This is a debt validation letter, and it also will tell you exactly where your payments have been applied, and you can check to see if they match your records. Without this, you don't know. You do not know anymore if your payment is going to your loan. There is no way to know for sure without this. I've got people contacting me saying, I've been listening to what you say and I'd like to pay off my loan, but I've called the servicer and I get shoved over to the Philippines and I don't believe a word they're saying now because it doesn't make any sense. So what do? How do I pay off my loan? How do I know that if I'm going to pay my loan, it's actually going to get paid? How do I know that? This is the problem. This is the major problem. Always use a qualified written request. And then we're coming down here. We're going in passing because loan modifications is number 8, but get copies of the foreclosure documents. Look at your documents. This is how standing is going to be demonstrated. And I just added this paragraph right this morning. Forged documents are a glaring sign that the foreclosing party does not have standing, doesn't have the authority to foreclose, and that is now a material violation in SB 900. So listen up, guys. Go look at your foreclosure documents. It is a material violation. You can sue them. You can sue them for damages both before they foreclose and after they foreclose, if it gets to that point. Here's my notary complaints. Here we talk about the suspicious documents. Here's the quiet title lawsuit. Here we're going to be considering applying for a loan modification. Without further ado, let's take a look at SB 900. I have linked this here and I have highlighted this so that you can see quickly, your eye can fall to what is really important. And this is just the summary. These first couple of pages are just the summary of the bill, where they talk about single point of contact. They talk about how none of the foreclosure documents can be filed unless they have complete, accurate, competent, and reliable evidence. They talk about the fact that now you can sue for material violations, and damages can be awarded against the lender for your attorney's fees. This is and up to $50,000. And if fraud is involved, treble damages. So there's some real clout here. How this plays out, which attorneys are going to really ramp up and do this, I don't know, but we will keep you posted. What I wanted to do is go into the actual law. And I have put on my homepage there under the SB 900 on page 11, see it's 11. This is where you can appeal the loan modification denial. So if you apply for a loan and you are denied, join the club. Most people get denied. That is the point. In fact, I've got a couple of articles linked there. I'm just going to quickly jump to them. And that is, this is a quick article that was done last November, how Obama's housing policy went off course. And I just want, these will all be linked, of course, to the comment section under this workshop. So you'll be able to click on these links yourself and look at them. But I wanted to scroll down here and read right here. According to one recent academic study, 800,000 families were rejected improperly or booted from the government's primary homeowner relief option, HAMP, which is what we're talking about, as a result of errors or misconduct on the part of mortgage companies. So they make a mistake, The family now has to live under the bridge, or they're living in a homeless shelter, or the kids are scared to death about their futures because some bankster either didn't do the net present value NPV calculations correctly, or they were just told to deny it. They're told to deny because foreclosures are so much more lucrative. This is the battle the owners are facing. So you got to understand that just because you got denied doesn't mean that was a valid denial. Appeal, appeal, appeal. And you're going to get a loan modification. Let's say you do, like this poor lady. This was just done, linked last January 25th, 2013, just a couple of months ago. Here's just an example. After 3 years of going back and forth with Chase, so then Chase gives them the ultimatum. Here's a loan mod, take it or leave it. You take it or I'll foreclose. Now that sounds like extortion to me. So they didn't see any way out, so they took it. But this is what happened. Instead of the payments going down, Chase rolled back payments. They kept the interest rate the same at 6 3/4. They increased with the taxes and insurance into the loan mod, and so the payments went up. And I hear this a lot. The payments went up. How crazy is that? And this is the problem. The banks got bailed out. They got gobs of money. The owners are thrown under the bus. We got booted out. And this is why I'm working so hard to make sure you understand all of your legal rights. So let's go back to SB 900. Here is the loan modification appeal. If they deny it, you appeal it, and you keep appealing it. There is no limit to the appeals. Also now, I wanted to scroll ahead. It's on page 19, and then on page 22, where it talks specifically about the other points I want to make. This one is an injunction. You can go to court and you can get an injunction. It's called a TRO, a temporary restraining order. If they have a material violation, the judge will give you an injunction. They cannot foreclose until they fix their lack of standing or their material violation, whichever one that is. Probably they're both about the same. So you can get an injunction, and then on page 22, these are the words that are music to owners' ears, and it says, a notice of default, notice of sale, assignment of a deed of trust, or substitution of trustee, recorded by or on behalf of a mortgage servicer in connection with a foreclosure, subject to the requirements of section 2924, or a declaration or affidavit filed in any court relative to a foreclosure proceeding, shall be accurate and complete and supported by competent and reliable evidence. SB 900 is your friend, and what SB 900 did was change several different foreclosure laws. This change is a rewrite, an addition to 2924.17. So this is one of the things owners need to start hanging their hats on. We know now they are required to have standing. You can appeal your loan modification if they deny that to you, and they cannot foreclose while you're applying for a loan modification. So those things in conjunction are very, very powerful. I wanted to also, I've got a couple of other articles linked here I want to just briefly talk about, and then I'm going to go into some other, the links and information that we've got for the loan modification, HAMP, and HAMP in particular. So here's an article. The foreclosure participants can be sued for material violation. I've pulled this out of an article. It's been talked about all over, but I liked this particular one by Mandelman Matters. He blogs and really has a good understanding of the whole foreclosure crisis, and it is a crisis. He's calling this a 9.9 earthquake in default servicing turns California into a judicial foreclosure state. Well, and that's because of the standing that I've been talking about. You can read the whole article. He talks about how several other states have changed their laws and basically said, okay, it looks like we're a deed of trust state where you can just take the house in 90 days plus 21 days, but no longer because of the potential liability. And so down near the bottom, I wanted to read these particular paragraphs. This is coming from the insider. This is from those that have reviewed the SB 900 and are predicting the future. Borrowers can sue mortgage servicers for injunctive relief, that means stopping the foreclosure, before the trustee's deed upon sale has recorded, or if it has already recorded, to sue for actual economic damages if the mortgage servicer has not corrected any material violation before the trustee's deed upon sale recorded. If a court finds that the violation was intentional, reckless, or willful, the court can award the borrower the greater of treble damages or $50,000. Court may award reasonable attorney's fees and costs to borrower as the prevailing party. And then down here, this other section that's highlighted. Many attorneys whom I have spoken with have said that litigation firms are advertising heavily to entice new attorneys to join their firms to help with a coming wave of litigation to be filed against lenders, servicers, and trustees. In this current economic environment, we all have become the targets and should brace ourselves for a barrage of borrower lawsuits, and this is being spoken by an insider, a servicer. The fact of the matter is, owners now have some rights, and we need to use those rights to stop the foreclosure on each of our homes and so that people can stay in their homes. I'm also working personally to show, I've already analyzed 18 properties of Recon Trust foreclosure trustee mill, and how every one of those documents on those foreclosures had something wrong with them. Either it was a forged signature, it was a false notarization, or it had some kind of an impossible beneficiary, or it named the servicer as an assignee, as the beneficiary, which is illegal according to federal law. And based on that, when all 18 of these are illegal foreclosures, I would think that it would be relatively easy to take that information and prove to the court that any violation by Recon Trust was intentional, reckless, and willful. So I encourage you to use whatever I've done, whatever information I've got out, whatever examples of forgery and fake foreclosure documents that can help you. And just as a quick aside, if you go into the my website, you'll see under the foreclosure defense that there's suspicious documents, right here. See, suspicious signatures. You go look that up. I update that frequently with more and more proof that all these people just willy-nilly signed whatever they needed to sign, and the notarizations were false too. So nevertheless, that's just a quick aside. Back down to loan modification, because this all ties together. I wanted to actually show you a couple of other pages. I've sort of pulled out some information. Here's some information specifically about loan modifications, some advice. Always, always insist on full disclosure of any fees that any modification company pays you, and I'm going to talk about that more when we talk about NACA. Here's where you can decide or figure out if Fannie or Freddie own your loan. If you are not yet in default and you want to try for a HARP loan, it's a qualified Fannie and Freddie loan before that there's the only ones that can be refinanced with a better interest rate. You can just check to see if your loan is owned by either Fannie or Freddie. And here is the free information, the free help for you. If you need help in modifying your loan, go here. Here's a national website, makinghomeaffordable.gov, and here's a California website, keepyourhomecalifornia.org. These are free government agencies designed specifically to help owners getting a loan modification. Use them. It can't hurt, but always pay attention to what's going on and never take no for an answer. I also wanted to point out that here is a link to the California cease and desist orders from the Attorney General. This is from the Attorney General's website, and it actually shows the people that have been accused of charging upfront fees and cheating others with that. And you can just click down here and see if someone who's talking to you already has a cease and desist order, and complain. Go to the Attorney General website. I've got that at the bottom of my foreclosure defense page. I'll click over here and show you where that is. You can go down to the California Attorney General website right here and just complain to the AG about anybody in California, any corporation, any individual, anybody doing anything that you think is not right. Go to the Attorney General website. You just log on, you do it, you just fill it in online. It's very effective. Believe me, I have filed many complaints myself now that I have that link so handy. So let's quickly look at HAMP. I wanted to briefly talk to you about what you can possibly expect with a HAMP loan modification. Let's say that they actually say, okay, you finally, push them into a corner and say, I really want a loan modification. Give me a modification. This is basically what you're going to be looking at. Before we look at the example, I just wanted to show you I have here the link for the HAMP rules. This is the website, HAMP overview, and here's all the rules: handbooks, income calculation worksheet, MPV model documents, annual servicer certification, on and on and on. It's a huge site, but that is right there available for you to peruse as you start working through your loan modification with the servicer. Now, here's an example HAMP modification. Yours may be different. I've seen different ones. I pulled this out specifically because I want you to understand what they're doing many times. It's a process. It's a paperwork form that actually says, okay, we're going to modify the loan and these are going to be the terms. And what you need to understand is that, and I've highlighted these categories here, that once you agree to the modification, if you break any of these terms, they can still foreclose. They can take the house. And I also wanted to say one more time to please remember that if you've stopped your payments and if they have filed a notice of default on your property, please understand notices of default never ever expire. Notices of sale will expire after 365 days, 1 year. But notices of default never do. And many times, people will agree to a loan modification. They will not insist or cannot get the notice of default rescinded, removed, made ineffective on their property. And so sometimes they're still making their loan payments and the servicer forecloses. They can do that. It's illegal. You'd sue them, but that's the point. They have all the rights, and once they do something, once they wrong you, now you have to try to stand up and fight and figure out how to do that. Just a word to the wise: if you sign for a loan modification, do everything in your power, including a complaint to the OCC, the Consumer Financial Protection Bureau, if that's the one, saying, I've agreed to this loan modification. I insist that they rescind my notice of default. At least then they can't just sell the house without telling you. So, word to the wise. Now, in this particular case, what they did for this poor woman was, it's a 40-year now amortization, so they've lengthened the term. You'll notice here I've got these two things highlighted. Here's a principal balance. This is the new principal balance, $392,000. By the way, the house at this point when she got it was worth about $220 in the market. So the new balance is $392,000. $68,000 of the new principal balance shall be deferred. Now, deferred means it's going to be a balloon at the end of the payments. At the end of 40 years, she's going to have a balloon. So now what they've done is they have split the principal into two pieces. One's interest bearing and the other is a balloon payment. So the interest bearing amount is $324,000. Now remember, that's about $100,000 more than what the property is currently worth. Now, in this one, they actually have a schedule of interest rates. For the first 1 to 5 years, it'll be 2%, and then year 6, it'll be 3, and year 7, it's 4. And year 8 to year 40, it's going to be 4.625%. And these are her payments, the monthly payment, including an escrow account. But you have to understand that all during this time that she's making those payments, the house value may be decreasing, may be increasing. Who knows what's going to happen in 40 years on this property. But at the end of the 40 years, after all of these payments have been made, the owner will still owe the $68,000. That's a balloon payment. Now, it says here, I agree to pay the full deferred, that's the balloon payment, and any other amount still owed on the loan documents if I sell it. If I transfer the house, if I sell it. So my prediction, my calculations, I pretty well figured that for at least 20 years, it would be upside down. And if she had to sell during that period of time, she would have to do a short sale anyway. So at least, in this particular case, the lady decided to take it because the payment of $1,300, actually the initial payment was $981. That's the payment, not the escrow, not taxes and insurance, which they've added on top of that. It was affordable. And this is what people are doing. They have to make these decisions. They're very hard decisions. They're not given what I would call good opportunities for good decisions. They want to keep the house. And I totally understand you want to keep the house. Absolutely. Do what you have to do. Just understand, do eyes wide open, what is happening, what the pitfalls might be for you down the road. So in this case, for this lady, she needs to make sure that she had no notice of default. Otherwise, she could make payments for 6, 7, 8 years, and they could take the house. They could file a notice of sale and in 21 days sell it. And by the time she gets notice, it's 5 days late. She only has 2 weeks, and they're going to sell it at auction. And she's going to be just like, what? And 2 weeks goes by like that. Who do I go? Where do I go for help? And the house is gone. So just be very careful. Now, I wanted to also show you that on every HAMP loan modification that I have seen, on item number L near the end, every last one of them requires that you continue to agree to allow them to use MERS, the Mortgage Electronic Registration Systems. This is a separate corporation. If you haven't heard much yet about them, just please go to my MERS Mess website, watch some of my live streams about MERS, and the fact of the matter is MERS is a computer database. It's an insider database that banks use to record whomever they like as the owner of the note. It is an umbrella for fraud, if you will. And so every HAMP loan modification is required to still agree that you allow the use of MERS, which, here they state, acting solely as nominee for servicer and servicer successors and assigns, MERS has the right to exercise any or all of those interests, including but not limited to the right to foreclose and sell a property. Just the word warning. This is a real dilemma for those that want valid loan modifications to have to subject themselves again to MERS when they have no right. Here's the question. If you disagree with that term, can you say, I'll take the rest of it? Cross off number L, I won't agree to that. I've encouraged people to try that. Most people are too either worn out, frantic, trying to keep the house. But this would be a very good fodder for some lawsuit for somebody that wanted to really go to court to see if the banks have the right still to require that in a HAMP loan modification. I think it's outrageous, personally. So, again, one last thing I wanted to point out, and I've talked about full disclosure on service fees for loan modification help. Here is someone an entity that claims they really help homeowners. This is NACA. And what's interesting is that what you've got here on my NACA page, I've made comments about the NACA disclosures. And I want to look at those first, and then I want to show you what I've said. What I've said in blue is they've responded to me. NACA wrote to me and said, you take that down. We don't like what you're saying. And I wrote back and said, I'd be just totally happy to take that down and put full disclosure when you tell me what your fees are. You tell me what fees those servicers pay you to help modify these loans, and then I'll fully disclose that. I'd be happy to. Never heard from them. So here's what you have to understand. This is NACA's disclosures. Please understand that NACA has agreements with the major servicers and investors. NACA is a nonprofit, they say, but NACA is not unaligned with the servicers. They have gone to the servicers and they have negotiated specific fees to modify your loan. Now, my argument goes like this. If that's the case, then they also know what that servicer is going to do, and they know that right now. They don't need to have people go to some central place and wait for hours and take days off work to determine if they're going to qualify for a loan mod or not. So why would they do that? Well, they hype interest. I'm not sure what else. Let your mind wander. Why would they want to do that when they already know in advance what their fees are and if that person's going to qualify? And so these are the disclosures. These are the disclosures that every owner has to sign when they go to a NACA convention and they sit down and finally talk to a loan counselor. I think it's to wear the people out and to get them into such a furor, and other people are getting loan mods, I'll want one, and they'll take whatever they can get. It's like an auction. You're going to an auction and the auction fever makes people pay more for junk than they would otherwise normally do. I believe that's the method to the madness. If we get all these people together and we stir them up and get them going, we'll do a lot more loan modifications and we'll make more money, says NACA. So these are disclosures. NACA may be acting as an independent contractor for the servicer of the client's mortgage. Yup. The servicer of the client's mortgage may pay NACA for each home-safe solution accepted by the client. Now, you know something? Not one person has ever been able to tell me, so what was that fee? What's NACA getting paid? How are they getting paid? Now, think about it. When you do a loan, if you're going to do a refinance on your home loan, or you're going to get a loan now to buy a home, there's just all kinds of disclosures, and that lender has to give you a good faith estimate. They call it GFEs. They have to tell you pretty much exactly now what it's going to cost, what they're paid, what your fees are. They can't have any hidden yield spread premiums like they used to. It has to be full disclosure. And California in particular is a full disclosure state. Everyone involved in transactions and loans are required now to do full disclosure. So why isn't NACA required to do full disclosure on their loan modification fees? That I want to know. And so ask them. If you're not desperate for a loan modification, go in and get NACA to work with you and just run them up and down the mill. Find out why they won't tell you what their fees are. I'll bet you ought to understand that those fees that NACA gets paid, they are rolled into the loan modification program. So you as a borrower going to NACA are going to be paying them. You don't even know how much. You have no way of knowing what their fees are because they are not required to fully disclose. And they're not disclosing. An interesting little caveat, isn't it? And besides, remember, you don't need them. You can do this yourself. You can go to Making Home Affordable. You can keep your home California. You can get free help. So why would you want to go to some independent contractor that's going to try to shove you into some loan modification? Especially like the one I just showed you on HAMP, where she's now got this huge balloon payment. And this is what happens. People get a loan mod, and then they come back, they settle down, they start reading the paperwork, and they go, wait a minute, this isn't going to work. I can't do this. Or I've seen even loan modification paperwork where they don't even talk about the interest rates. They just say it'll go up, and they won't even tell you how much. And so then the owner says, well, Wait a minute. They ask me. They'll send this to me and they'll say, well, should I apply for this loan mod? And I said, well, now this is insane. If they won't tell you what the interest rate is, just that next year it could go up any time, then how can you actually agree to that? You're agreeing to whatever they give you. That's not a true loan modification. I would, well, it's easy for me to give advice, but when you're in the boat and you're trying to keep it afloat, and you're desperate to keep your home, this is when people can be extorted. So I encourage you, if you know anyone, any of your family, friends, neighbors that might be in this boat, step up. Let them know that they're not alone. Help them understand they have rights, rights, rights. They now have rights with SB 900. They can, the dual tracking can be stopped. They can postpone a foreclosure auction. They can appeal a loan mod denial. They can insist, and that's the qualified written request letter. Start sending those out, because that's a debt validation. And debt validation by definition means we're going to validate how much, where all the payments went, for sure, and who owns the note. Who is my lender? Send that out. See what kind of information you get. That'll help you really understand the lender's standing portion of SB 900. And then as things progress, I'm confident there's going to be more and more legal help available for owners for the material violations. Now the attorneys have a law that they can use. They can go into court legally with a new law to help people keep their homes. I hope this has been helpful. Please don't hesitate to email me your questions and comments. I'll get to them as soon as I can. I appreciate your time, and very best of luck to you. May you, in all cases, be able to keep your home from foreclosure and be able to keep it and live in it peacefully in the future. This is C.J. Holmes, founder of Homeowners for Justice.